Navigate the journey to becoming a great lawyer with expert guidance on topics that range from trial skills to corner office management. Here you will learn how to tap into your potential for legal greatness. I'm Andrew Smiley, and this is The Mentor, ESQ.
Great to see everybody today. It is a hot one here in the Northeast, so wherever you are tuning in or if you're listening on the podcast, thank you. Hopefully you're someplace nice and cool. Looking forward to this final third part of this three-part series on successfully litigating personal injury cases in federal court. Today we're going to talk about motion practice in federal court. I know a lot of you have just been anxiously awaiting today because you really want to learn more about motion practice in federal courts, and I'm looking forward to chatting about it. Before we get into it, just a couple little things I want to bring to everyone's attention. First off, if you are not aware, it means Michelle and the Academy is not doing a good enough job of promoting it, but we have our big annual membership reception and induction of our new president, Andrea Bonina, next Thursday, which is June 12th. Obviously, if you're listening to this delayed on the podcast, you probably missed it already. But if you're live with me now, we welcome you to come. We hope you will join us at the membership reception in Brooklyn on June 12th. Michelle can provide you with details if you need it. Michelle will be there. I will be there. Andrew will be there. My father, Guy, my partner, Rosa, my partner, Jason, Sally. So it'll be a great time for all of us to meet up and get to know each other even more. Also, if you and I have not met yet, I encourage you to please meet with me for a complimentary Zoom. The link can be found in this flow code next to me. Just hold your camera up, scan it, it'll open up, and you could schedule a link just to talk about anything and everything. Also, Q&A will happen at the end of this first hour, the last half hour between 2 and 2:30. I look forward to taking your questions. And during the breaks for polling and announcements, I'll also take a quick look. But please chime in. This is not your first CLE with me. And so you know I love questions. I love the interaction, comments, questions. Put it in the Q&A and we'll get to it. All right. So today let's talk about motion practice in federal court. Now, as I've been talking about in the last 2 episodes, if you are practicing in federal court, even if you've got that one case in your firm that's a federal case, take a deep breath and relax, because the best thing about federal court is it's uniform across all the districts across the United States, and there are rules. So you have to follow the rules consistently. The rules are really easy to find. They're easy to look up with a quick Google search, and they will give you the answers. So 75% of the questions that people ask me about federal practice, there is an answer for in the rules. So there are really 3 rules that you look at in federal practice, and especially in motion practice. You're going to look first at the Federal Rules of Civil Procedure, which I provided a link to in part 1, and you could easily Google it and get a PDF download, and you can search online for whatever topic it may be, especially motion practice, which we'll talk about. You'll also want to look for your local district's rules. So in New York, if you're in the southern, eastern, western, or northern districts, then you're going to want to look up the rules, the local rules for those districts. Again, Google it, look it up online, you'll find those. Then the third set of rules you're going to want to look at is going to be your judge's individual rules. And that can be your magistrate judge as well as your district court judge, which we'll talk about depending on what the issue is. You're going to want to make sure to check both of their rules, because magistrates and district court judges have different rules from each other and from other magistrates and other district court judges. And if you don't follow the rules and you file a motion when you were supposed to contact the court first, you get in trouble. So make sure you follow the rules before you file anything on whatever motion it is you are contemplating. I'm going to reel off a few of the rules so that you know at least the federal court rules. Federal Rule of Civil Procedure Rule 7 is the rule that will govern motions generally speaking. Federal Rule of Civil Procedure 56 is the rule that governs motions for summary judgment. Federal Rule of Civil Procedure 12 governs motions to dismiss. So these are really good starting points. Think of these as the general rules. But then you're going to look at the more local rules that are going to really be the controlling ones. Okay. There's also a local rule 7, which corresponds to Federal Rule of Civil Procedure 7, which most courts have. So look at all of these rules when you're contemplating any type of motion practice. Okay. Now, discovery motions are something that we all spend a lot of time with in state court practice, right? You don't get the discovery you want. You're the plaintiff, the defense isn't giving you what you want. You're the defense, the plaintiff isn't providing what you want. No depositions, no discovery, whatever that is. Those types of motions that are very frustrating, that have to be made in state court when your adversary is not complying with a preliminary conference order, a compliance conference order, discovery orders. They're not complying with the CPLR. In state court, your only option is to file a motion, which then can sit for months and months and months, and your case just drags on. Well, one of the great things that I always talk about in federal court practice is that usually is not the case. In federal court, if there is a discovery issue, I have found it to be extremely rare that a motion ever has to be made to resolve that discovery issue. If you have discovery issues of any kind, you're going to go right to the magistrate. Or if your magistrate is not assigned to oversee discovery in your case and you are just working with the district court judge, you go right to the district court judge. Again, you're going to look at their rules. Most of their rules will say that if a discovery dispute arises, you must try and work it out with your adversary in a meet and confer. Meet and confer can be a phone call, it could be an email, a letter, basically saying, and you should spell it out, I'm reaching out to you in an attempt to resolve this discovery dispute. You have failed to provide fill in the blank, whether it's a deposition or specific discovery, or you failed to respond to my 5 discovery demands from the last 6 months, dated so-and-so. Please address when we will be provided with this. Otherwise, we will have to contact the court. Please consider this our attempt to meet and confer in an attempt to resolve a discovery dispute. So you're going to want to put that in writing, by email preferably, or letter, save a copy of that. And then most courts, the judges' rules, whether it's a magistrate or district court, will tell you to file a letter. And in that letter, you'll tell the judge what the issue is. You'll say you've attempted to meet and confer. You can even cite or attach the exhibits of your meet and confer email and any responses you got, saying we are unable to resolve this issue and we are asking for a conference with the court. You will usually get a response within a few days. It's rare that a week goes by when we file one of these discovery dispute letters that we don't hear from the court. And generally, the court will issue either an order right then and there, directing discovery be produced by the delinquent party by a date certain, or more times than not, they'll set up a conference call where you dial in and they will address the specific issues in dispute. And that will avoid the need to make a motion, okay? Sometimes they may ask you to brief out the issue a little bit in letters, but it's really rare that you're going to have to get into motion practice in federal court on a discovery dispute, which is wonderful. One of the reasons I like it. Things get resolved fast. Depositions move when they're supposed to, okay? Now, sometimes I've been in federal court where we've had a discovery dispute and then the court will ask us to brief it as a motion with a memo of law, and we're going to get into the substance of these motions, but that's rare. I've had that happen. I had that on a product liability case where we were demanding prior incidents, prior records, prior information. They were arguing on the defense side that it was too far outside of the scope, not relevant, not probative. We were asking for the judge just to issue an order saying, give it to us. It's discovery. Doesn't mean it's going in at trial. The judge made us brief it all. So that will happen, but it's rare. Okay, so don't worry too much about discovery motions. Those will generally be resolved by letters and conferences. All right. What you do want to be concerned about is substantive legal motions. So the 3 primary motions that we see in our firm, in our practice, in federal court is, first of all, summary judgment motions. Secondly, declaratory judgment actions. That is the primary motion that's filed in the insurance coverage work that our insurance risk division, chaired by Rosa Feeney, handles. Lots of declaratory judgment. And then lastly, what I'm really going to talk mostly in detail about today is motions to exclude expert witness testimony. All right. These substantive motions will always go before the district court judge, with the exception of whether you consent with your adversaries. If everybody has consented in the case to have the magistrate be deemed to oversee everything, including trial, and the district court has issued that order saying it's all the magistrate, has the full authority for everything, then it will be the magistrate that will hear these substantive motions. But if you have not consented to the magistrate to oversee the entire matter, including trial and motions, then these substantive motions will go to the district court judge. So you do want to check the district court judge's rules. And if the magistrate judge has the consent to oversee the case, and you will see that, by the way, on the PACER ECF filing system, right at the top when you go into file and your case pops up, it'll say MAGCON, like magistrate consent, usually an abbreviation. If that shows up on your docket when you go into the online system, then you know the magistrate's going to be deciding every motion, and you definitely want to check the magistrate's rules regarding filing. We had an interesting issue come up in a current case that we're litigating in federal court where we were in the case, we filed it, we had one defendant answer, and that was it at the beginning of the case, and we consented to the magistrate to oversee everything, and there was an order issued. Thereafter, there were some impleaders, some third-party actions, some new players, some new defense firms involved, and they never consented. So when we went to file a summary judgment motion, we looked, I presumed it was going to the district court judge, and we filed it. And because we checked the district court judge's rules, it didn't say anything about having to wait to file it. So we just filed our summary judgment motion. It got bounced. We were reprimanded by the magistrate for failing to comply with his individual rules, which requires that we submit a letter about what the motion is going to be, whether we've set a briefing schedule. And then we had a conference about it, and I explained to the magistrate the issue and why what we did. We checked the district court's rules, that we didn't believe the magistrate had full consent, and he acknowledged that. He said, "Oh, Mr. Smiley, that's right. I see here that is an issue. I can't handle this motion unless the additional parties have consented to me taking over the case," to which he gave them a week to consent or not, and they chose to, and so now it's properly before him. So again, really important to check on the rules.
If you're joining us today via podcast, the first attendance verification code is POD 605. Again, POD 605.
All right. Now, getting back to the motion practice that we're talking about here. Now, form of filing of motions is really important here, because if you mess up in how you present your motion, how you file your motion, it's going to get bounced. And if you keep refiling it and something's wrong, if you're not complying with the rules, if you don't have things in proper form, you're going to really look bad, because it's going to get bounced. You're going to look like you don't know what you're doing. And that's not good. And it's not good for your client. And it's hard to explain why you're not able to successfully file a motion that can help your client on behalf of the plaintiff or the defense. So there's some differences that I want to make sure to go over with you now. So if you are filing a motion or receiving a motion, you know what to look for and what to do. The first thing is, in state court, many lawyers will tie in their legal arguments with their attorney's affirmation. So we call those briefirmations. So there's no separate legal memo of law. And that is not proper practice at all in federal courts. It's not really the best practice in state courts, but my understanding is it's pretty much permissible. So in state courts, you generally see, at least I see in New York State Court, you'll see an affirmation in support of a motion to dismiss, let's say from the defense, or a motion for summary judgment from the plaintiff, or whichever side, it doesn't matter, but it'll be affirmation of Andrew Smiley in support of motion. And then in one document, hi, I'm Andrew Smiley, partner in the firm, fully familiar with the facts of this case, declare the following under penalty of perjury, facts, right? A whole fact section. Law, argument, and you have all the law, you tie it in with the facts, and then you ask for the relief that you're seeking. We see that a lot in state practice. That is not going to fly in federal court practice. In federal court practice, and really state court practice, you should try and start mimicking the federal way. It's a lot cleaner. I think it's better for appellate review. It's safer, depending on the rules of your judge as well in state court. But what you're going to need is your main document when you go to the filing system. And by the way, if you haven't handled a case in federal court, you must use the PACER system. You have to get a PACER account. You have to log in through PACER, and you can get into any district court in the nation through the PACER system. It's synced up with the federal court system, and you have to register. You have to make an appearance in there if you're not the one who has filed. And that's how you're going to file your motions as well as everything else that you need to file in a federal court case. One of you had reached out to me to ask for training on this. My firm doesn't do training on PACER systems. So the best thing that I suggest you do is you can reach out to the support. There's a lot of help desks with PACER and the federal court filing systems. They also have manuals online that can sort of walk you through how to do these filings. But there's going to be, when you go to file a motion, there's going to be a spot where you file the main document. It'll say main document. And that is going to be your memo of law. Your legal memo of law is going to be your main document. So you type in memorandum of law, and then you click browse, then you pull up your memorandum of law, and you hit attach, and that's your main document. Then on the screen below it, you're going to have the options for attachments, okay? And those are going to be where you're going to do your affirmations, your declarations, your affidavits, and all your evidentiary exhibits to support your motion, whether it's documents you've obtained in this discovery, whether it's transcripts, whatever it may be. So you'll have the main. So let's say the docket, it gives you numbers based on filing. So the very first filing, let's say it's a summons and complaint, is going to be docket number 1. And then an answer will be docket number 2, and so on and so forth. The dockets get up there really fast. I have some cases where we're into the hundreds in the number. But the main document would be, let's say, item docket number 85 would be your memorandum of law. Then 85-1 would be an affirmation. 85-2 will be an affidavit. 85-3 will be exhibit, transcript, and so on. All right. So you need to make sure that you file these documents appropriately. You have to give titles to them all. So it would be, and there's categories. So in all the attachments, so you click on the pull down, it may say most of them are exhibits or affirmation or declaration, but generally you'll be doing exhibit and you'll name it exhibit 1, and you have to give a brief summary. So exhibit 1, transcript of plaintiff's testimony, exhibit 2, invoice, exhibit 3, contract between defendants. So you're going to list all of that. And then you hit submit. Sometimes you run into issues and it doesn't work. For example, if you try to submit a document where the PDF file is too big. I had that happen recently. For some reason, a transcript was showing as like this 30 megabyte file when it should be much smaller. And most of the filing systems have a limited amount of space, so they won't let you file anything over like 5 or 15 megabytes. So then you're like, oh, I just did this whole filing, it got bounced. You have to do the whole thing again, and you got to make sure you condense your transcript so that you have a smaller size. If you need to submit like videos to the court, which sometimes we do, then you put it in as a space holder, and you actually have a document that you will file. So let's say you have a video of the incident you want to include. You could call it Exhibit C, video of incident placeholder. and then actually have a piece of paper that says Exhibit C, placeholder for video, original being sent to counsel and court. And then what you will do is you will take that DVD or USB drive, you'll FedEx it to the chambers with a cover letter, enclosed, please find the video, which is Exhibit C in the motion. Always reach out to chambers and ask their preference before doing that of how they want to receive that type of information. So if you have a video that's too big to upload or any other item, also check, you may need to send a complimentary courtesy copy to the judge. Again, check their rules. Rosa is working on a coverage case right now in federal court where they want one lawyer to file everything at the end. So instead of filing your motion and then the adversary filing an opposition and you filing a reply, this judge wants everything filed when it's all done by one of the lawyers and wants courtesy copies to chambers. So you have to go and print everything out at, Staples or wherever, Kinko's, and send it. So really check these rules, okay? Because you want to be on the right side with the judge overseeing your case, and you want to make sure things go smoothly and efficiently. You don't want to take up weeks of time, because you're not sure how to file. So make sure you have your legal memo, then the attachments, which will usually start with the attorney's affidavit, affirmation, or declaration. I want to talk about those three for the moment. The nice thing about federal court is you don't need notarized documents from lawyers or lay witnesses. You can use what's called a declaration. You can always type up and search federal court declaration, but I'll give you the law. It's 28 U.S. Code Section 1746. 28 U.S. Code Section 1746. Unsworn declarations under penalty of perjury is what it's called. Declarations are awesome. You've got an expert, you've got a lay witness, you've got the plaintiff, the defendant, a witness, whoever it is. Don't worry about a notary. You prepare the document. It's entitled a declaration, and it starts off by saying, I, lay witness, being over the age of 18, swears under the penalties of perjury pursuant to 28 U.S. Code 1746 and declares as follows. Boom, then just a signature line with a date. That is sufficient. A lawyer can do it, and any other individual can do it. So declarations are great. You don't have to worry. Affidavits are pretty much history, but lawyers can also do affirmations. So sometimes if you have a lot going on, I like to do an attorney affirmation. I feel sort of old school that way, like attorney affirmation I do, and then we'll have experts and witnesses do declarations. All right. So that's a nice practice tip of being able to use a declaration. Saves time, saves the ability to have to get a notary, especially if the witness is out of state. There's been motion practice about whether things are properly notarized or where the notary was or if the witness was out of state. I've seen my adversaries try and bounce motions because of issues with the notary. So to remove all of that is really nice not to have to deal with that. So use declarations. They're a great tool. In addition, you're also going to need to file, in addition to an attorney's affirmation, the legal memo of law, you must, and most state courts in New York for sure now require a statement of material facts, okay? So what I gave you in the materials here, you don't need to look at now. They're pretty robust. I think it's like 86 pages. I gave you an motion, an attorney's affirmation or affidavit is in there. Our legal memo of law is in there. And the decision is in there that the district court rendered. I didn't give you the statement of material facts, but you must do a statement of material facts. And basically, you are laying out the facts of the case that you think are pertinent to your motion. All right, that's in the statement of material facts. For example, in a car accident, on such and such date, the plaintiff was driving a Toyota Corolla bearing license plate so-and-so. You have to have a cite at the end of that statement. You can cite to the complaint if it's verified. You can even cite to the docket number of the summons and complaint. Citing to docket numbers is totally cool. In our office, we actually hyperlink to that docket number. So all the court has to do is click on it in the motion. It'll go right to the docket and open up. And let's say the plaintiff was going straight and had a green light in her favor. And you'll cite maybe to the transcript of the plaintiff, see Exhibit A, transcript page 33, and so on. The car was owned by such and such, and they had a lease agreement pursuant to, there was a contract, and you cite to that exhibit, right? So you're going to cite to everything in the statement of material facts. The attorney's affidavit, affirmation, declaration in federal court really only serves the purpose of saying you're familiar with the case as the lawyer. Next here to as Exhibit A is, and next here to as Exhibit B is. That's what we do in federal court practice in our firm, and most attorneys will do that. The attorney's affirmation or declaration is basically a vehicle to identify the exhibit letter or number with the exhibit and annexing it thereto. All right. Then the statement of material facts and the memorandum of law, when you are referencing the exhibit, you just reference that exhibit. Okay. But you use the attorney's affirmation or declaration to list everything in one spot. Makes it nice and easy. So that's going to be usually the third thing that you'll have in, the second or third. So you have the legal memo as your main, and then the first attachment is usually the attorney's declaration or affirmation or the statement of material facts. Then the next one, either the statement of material facts or the attorney affirmation or declaration. And then you just go through chronologically, exhibit A, B, C, D, E, F, and so on, until you have all of your witness, expert, lay witness declarations, transcripts, and exhibits listed there. All right. And the same thing for cross motions. Oh, one more thing you also need and is required by most local rules, which we all have to do in state court practice, is the word and or page count certification. So the lawyer at the end of the memo of law, usually at the end of, if it's a long affirmation, definitely at the end of the memo of law, you are going to need to have a certification showing that you comply with the word count. And that's really easy to do. You pull up your document in Word if you don't know this trick. And under the rules, you don't have to include the caption or the signature block in the word count. And then what you do is you open up your Word doc and then you do like a copy and highlight. And then you highlight all the way down, starting below the caption, all the way down to above the date and signature line. And then if you look to the bottom left of your Word document, it'll say something like 4,508 out of 5,200. What that means is you're going to certify that your legal memo of law is 4,508 or whatever number I said, which is the smaller number. And the larger number is adding in the caption and all of that. So make sure you have your word count. Sometimes the courts want it to be pages. You have to be within a certain amount of pages. I think mostly now they're using word count, not pages. But again, check the rules and make sure you certify. And you can either do that as a separate exhibit, or the easiest thing is usually just to attach it to the back as an additional page after your signature line on the legal memorandum of law. If you are opposing the motion, whether you're plaintiff or defendant, if you're the non-moving party and you're either opposing and or cross-moving, you must submit a counter statement of material facts. And what you will do is you will submit the facts that you think are probative, and you will cite to your exhibits if they're not mentioned. And you also want to respond to the statement of material facts from your adversary in there. So you could do it as one document or two, whatever you find to be easiest. But as a counter statement, you're basically going to list the movant's list of all the facts, and they may not be submitting it right. They may be putting in things like opinions, like the plaintiff wasn't paying attention at the time of the accident. And then they cite to the transcript of the plaintiff, and there's nothing in there that's saying the plaintiff wasn't paying attention. It's just the defense may be trying to argue an opinion. That's not appropriate. So what we do is we respond and say deny or reject the above statement as not supported in a misrepresentation of the evidence. This is an opinion, which is not appropriate for a statement of material facts. So you need to call out your adversary if they're citing to something in the record that's either misreading of the record or misleading the court. So if they're cherry picking, let's say the witness says, I woke up early that morning, but for me, it wasn't really early because I get up at 5 all the time and whatever it is. And then the adversary puts in the statement of material facts is, they woke up really early for them. And then, but further on, the witness is like, it wasn't early for me. And you want to highlight that additional statement to show they're taking things out of context. Because the statement of material facts is what the judge or the judge's clerk is going to use to get a handle on what's probative in the case. And if you don't submit a counter statement of material facts or your own version of the material facts, then the court is going to deem those material facts submitted in support of the original motion as real and valid and not disputed. And then when they write their decision and they summarize the facts at the beginning of the case, that's where they get it from. They'll say the facts of this case, the undisputed facts are as follows. And they're going to list a lot of things. So don't give short shrift to the statement of material facts. It's usually a nice starting point when you're drafting the motions to start with the statement of material facts. It's a nice way for you to sit and pull together all the evidence you have. And of course, as you're getting into the law and you see something in the law, let's say in a labor law case, if it's a construction accident, and you're dealing with a height-related matter, you're going to want to have to support a labor law 240 scaffolding argument in your summary judgment motion. You're going to want to have the facts from the case in your statement of facts saying something like they were on a scaffold 24 feet above the ground. And then this is not disputed by the contractor at the site. And then you cite to their testimony. In your deposition, you need to make sure you lay the groundwork for these motions. We're going to talk about that. You need to get those apples, I call it, that you're going to pick out, picking apples, the important things in your case. I talk about this in trial, in cross-exam, and in in direct and cross. The elements you're getting out are your apples you're picking, and you mix them all up at the end to a pie, and you serve it to the jury. Same thing here. Your deposition is to get these nice apples to support your motion that you could cite in your statement of facts. You can weave into the applicable case law to serve it up to win your motion. All right. So those are the things you're going to have to make sure that you do when you're filing. You're going to need to have the memo of law, your affirmations, your statement of facts, your declarations, and your exhibits, and file it timely and in accordance with the rules. Now, I want to get into now specifically what's different in federal court as far as substantive motions that I see from state court. I'm not going to talk about motions for summary judgment. Just follow the form that I just talked about. Make sure you put your law in a memo of law, have the right exhibits. And generally speaking, it's going to be the same thing you're doing in state court practice. It's a motion for summary judgment or a motion to dismiss or whatever it may be. The substance and the arguments are generally going to be the same in state court as they are in federal court, albeit the form and timing and everything in federal court is a little more buttoned up. What I'd like to talk about, which I think is fun, this is one of the things that I enjoy in federal practice, and this ties into what we spoke about last time in part 2 in depositions, is motions to exclude an expert. This is something that really generally you see happen in federal court and only rarely in state court. And if it is in state court, it's going to be a motion in limine. And again, you're going to want to follow the court's rules for in limine motions and briefing that. But it's different because in federal court, we have expert discovery, right? Which you don't have in state court, in New York State at least, and in many states. Some states have expert discovery, but New York doesn't. So once you've taken the deposition of your adversary's expert, whether it's a liability expert, a causation expert, a damages expert, and you think that, there's something that doesn't seem right there, you can make the motion and should make the motion to exclude the witness from testifying and or to limit what they can talk about, limit their testimony. Now, it is called a motion to exclude. It's not a motion to preclude, which makes more sense, but these are called motions to exclude in federal court. And there are various reasons why you would want to move to exclude an expert. This is where we get into Rule 702, which talks about expert testimony and the reliability that's required for an expert to testify at trial. And we talk about the case of Daubert, D-A-U-B-E-R-T versus U.S. And the Daubert case is the main case. We've all heard of that. The equivalent in state court is Frye, F-R-Y-E. In Daubert and its progeny, if I'm using the word properly, all the cases that follow and flow from it are what you're going to be researching. There's lots of case law. I'm proud to say that my firm, we've made some really good case law in this area, including the case I'm going to talk about here on precluding experts from certain types of testimony. And it's basically what I like to call, and excuse my language, but this is the calling bullshit motion. You're calling bullshit on the expert that your adversary has retained. And here's what this is all about. Experts can get on the stand with their PhDs, their medical degrees, published books, they're the leaders in their field, and if they get up on stand and say something, a jury most likely is going to believe it and put a lot of weight into it. And that means even if they're talking bullshit, okay? And they're trying to come up with an argument and this interesting, and they talk about their models and their studies and their calculations. And it gets so confusing that we can't understand it as lawyers. Judges can't understand it. And jurors sit there dazed and they say, well, man, this person did all these forms and has all these degrees. If they're saying it, they seem to know what they're talking about. They're on staff at this college, the university, they lecture, and it can totally ruin your case if your adversary's expert gets up there, presents nicely, as well credentialed, and talks bullshit, right? So you need to be able to call them out on it. And there's nothing I like more than to call out an expert on their bullshit and to get them precluded from dishing that bullshit to the jury and confusing the jury to hurt your client's case at the time of trial. So in federal court, you always want to have an eye on whether or not this expert, what their opinion is and how they get to that opinion, whether they're just, something doesn't pass the sniff test, and it takes homework. You need to look into it. You need to do your own research and say, is this real? Are they just coming up with this? Is this really out there? Do they have the basis to say this? Just because they're saying that this couldn't have happened this way based upon their analysis, says them. Let's see how they get to that point. So what I gave you the example of, I talked about this last time, is this guy, Irving Schur. I dislike him. Hopefully this will stay out here forever on the internet. So when people search for him, they'll come across stuff on this expert. And the fact that we made case law, the decision that's included in these materials, I think is going to keep him from hurting other plaintiffs. So Irving Schur is the biomechanical engineer who is recently well known for the Gwyneth Paltrow ski case, who came up with some animation and the plaintiff lost the case. Primarily because this guy came up with this video animation that shows that what the plaintiff said happened in that collision couldn't have happened. And he created this model and it showed skiers and colliding and angles, and it looked very impressive. And I was sitting there watching this on TV and I was like pulling my hair out, if I had any hair, but I was going like this, saying, how did this get into court? This is such bullshit. The jury's going to believe it. I can't believe the plaintiff's lawyers are allowing this and didn't move to preclude this. So here's what happened in this case. Irving Schur I've dealt with on 2 ski cases and 1 case that I talked about in the last part that was a resistance band that slingshotted into someone's eye. So he came up in the ski case we had with this whole computer model that he used. And basically, he punches stuff into a model. There's software. It's called Madymo, M-A-D-Y-M-O. It's a computer model that you can put all kinds of data into, move things around, and try and measure values of impacts and locations of impacts and positions. And he does all this computer modeling to form his opinions that this person must have been skiing too fast, or this person must have caused this accident. And he shows this model, and it's very impressive, and jurors believe it. And I know, because I've done the research, that it's bullshit. And so I wanted to call him out on it. There is modeling that is done in the industry by biomechanical engineers. They do a lot of it in auto crash testing. It's how they figure out using airbags and safety restraints. But that's very different. And the studies that do that are well documented. They are published. There are details, there are data, there are studies in the industry that they are shown to be reliable. They do real life testing. So they'll do computer models, but then they'll do actual crash testing. They'll put a dummy with biometrics that control where they get, it's amazing the technology. We did testing in this case that I gave you. We did our own crash testing. We hired the biomechanical engineers. We got these biometric dummies that literally you crash it into a pole and it shows what would have been broken, what the forces were on the body, all that sort of stuff. And then you can compare that and those results to a computer model, and you see how closely aligned they are. And if they're not even close within a statistically significant margin of error, then they're without value, right? So what he did in this case is he came up not only with a computer model and formed all of these opinions, which he was going to use at trial to use against us, but then he went so far as to then say that he couldn't have sustained the injuries he did in our case because of this speed, or it was his speed that caused these injuries and not something else. But he was talking about our client's injuries. And what many of us don't know and presume is that a biomechanical engineer, at least in the Second Circuit, and I think pretty much in my research and all the circuits across the United States, except for a few that are not followed, but the governing law, and it's very clear in the Second Circuit, is that a biomechanical engineer who does not have a medical degree, who's not a medical doctor, cannot opine as to whether or not an impact or a force could have caused the plaintiff's injuries. And I'm sure some of you are shaking your head and saying, really? I get these served on me all the time. How many of you have had a case where there's a plaintiff driving a car, there's a rear end accident, the plaintiff sustains an injury to a knee or the neck and has surgery, and the defense serves a biomechanical engineer expert report saying the impact was too light, it couldn't have caused these injuries? I'm sure if we were in a room, I'd see many, many of you raising your hand. Well, guess what? Look at the credentials. If that biomechanical engineer is not a physician, does not have a medical degree, then you need to move in limine to preclude that in state court, or move in federal court, do a Rule 702 motion to exclude and cite the law that you'll see that I cited in my case, because they can't do it. They're not allowed. They can't talk about injuries. They don't know. They're not trained in medicine. Their biomechanical engineers are only trained in forces. Forces put on someone's body, forces that are generated. So they can say the force generated here would have been similar than the forces that studies show happen in a car crash. They can say things like that, but they can't say that the force would or would not have caused plaintiff's injuries. So the two main areas that we moved to exclude Irving Schur on was one, that his model was not reliable, and two, that he can't comment on whether or not the forces could or could not have caused the injuries. He can't talk at all about my client's injuries. All right. So knowing the law and having done these motions before, I knew going into the deposition what questions I needed to ask. As far as the modeling, I needed to ask what data he used. Did he know the speed at the time of impact? Did he know the angle at the time of impact? Did he know the client's weight and height and all the things that you would need to do a basic equation of speed equals mass times force, or force is mass times speed, whatever it is, you need all the data. And the case law, which you'll see that we cite, and the judge granted our motion, you'll see on both of these points, is that an expert's opinion is only as good as the data they rely upon. So if you're in a case and an expert's exchange and they're like, oh, and they start talking about speeds and forces and angles, but they don't know the angle, they don't know the speed. What do they know about the conditions? Was it a slippery road? Was it an icy ski slope? Was it slushy? What do they know? Because all of these things go into computing forces and impacts and locations and severity. So you need to prepare the deposition so that you can have all of the answers. So when I took Irving Scher's deposition, which I didn't bother giving you here because it would add, but I can if someone needs it, reach out to me. It was very long. I think 8 hours or 9 hours I spent grilling him. And you have to go through all the studies. You have to demand before the deposition their file, their references. If they cite any references in the report, you have to pull them. You have to read through all of them. And what I found out is that Irving Scher was unable to cite any computer model that showed what he was attempting to show that was documented in a scientific journal as being valid. There's something called validity testing. What I spoke about, that the model matches the real life testing, that it's reliable, that if you put all the proper data into this model, it will actually spit out reliable information that would mirror what happens in real life. If they can't do that, if they can't show that the computer matches real life crash testing, then they are going to be excluded. And that's what you'll see the focus of our argument was. And that's why the judge decided to preclude him. And why this is so important is that this was in district court in Vermont, and that's the Second Circuit, where we all are in New York, Connecticut, and Vermont is the Second Circuit. We've made law, and that same law, this is now the second time that Irving Scher has been precluded in federal court, or maybe even the third for his computer modeling. And now if he tries to do this in any other federal case, a litigator who comes across him and is doing their homework is going to pull up all of our cases and say, look at him being precluded. In my deposition that I took of him, I go through all of you were precluded here. They found your model was not reliable. You were precluded there. And then you cite that. You'll see I cite it in the motion. So you really, to build a strong case to preclude, you have to build it. So you have to go into the deposition building it. So what'll happen is you'll see my motion. You put everything in there. You cite to the law. Please use my motion for any motion to preclude. The law is all there. And then you can just sort of cut and paste. And it'll also, you want to read my motion before you go and question a biomechanical engineer. All right. I have other types of motions that I'm happy to share, depositions rather, when I question medical experts. Because just because someone's a neurosurgeon, I have a case now involving a traumatic brain injury. And they're experts, a neurologist, not a neurosurgeon. He's a neurologist. And we have a neurologist. And I prepped with my neurologist before the deposition, and he said, "Oh yeah, I know this guy. I've worked with him. He's a neurologist, but he doesn't handle traumatic brain injuries. He deals with stuff peripheral. He deals with nerve issues that affect the arms and the limbs. So ask him if he knows or is qualified to read an EEG, which measures brain activity. And if he says he does, he's lying." So of course I questioned him. He says, no, he doesn't really treat traumatic brain injury people. Maybe he sees a couple a year. I asked him if he knew my expert. He did, and he knows he treats a lot of traumatic brain injury people. And I said, do you even know how to read an EEG? He says, nope. So I don't do that. So it's all preparation, and then you could move to preclude. Just because they're in a field doesn't mean that they have an expertise to opine. You have to look at what opinion they're giving, okay? So take a look through the motion, take a look at the decision, use those examples because they're really good examples to use to move to preclude. Now, what may happen, and then Michelle will let you hop in here and then we'll wrap up, is you may have a Daubert hearing. So what happens? So we make our motion, they push back, the adversary will push back. And again, either side, defense or plaintiff, can make motions to preclude. We've had them made against our experts as well. So you have to do your homework in the case law. You have to get declarations from your experts to support further their opinions and why they're reliable, or your expert saying why the other expert's not reliable. Then the judge can either A, decide it just on the papers and preclude a witness or not preclude a witness, or B, they can have what's called a Daubert hearing. So in this case, we had a hearing. The judge read all the papers and ordered a hearing. And basically, it's like another deposition, but you do it with the judge sitting there. So what you'll do is you do it sort of as like a cross-examination. So I had to prepare to do a full, and it lasted probably, we did it over 2 days in front of the judge. I think it was like a 4-hour Dalbert hearing, where first I started and I grilled him in front of the judge. And the kind of, you know, answers that they try and slither out of, that doesn't fly when the judge is there. And I said things during the Dalbert hearing like, tell this judge right now, not just because you say so, but tell this judge one study that supports your opinion that you just gave. Well, I don't have it, but I have a PhD. And then the judge even jumped in this case, said, sir, I'm having a hard time following you. And my job is as the gatekeeper is to make sure a jury's not confused and just believes you, right? So you'll do a Dalbert hearing where the challenging party will usually go first, question the witness on the stand, and then the person who's hired that expert has the chance to rehabilitate, try and show why it's reliable, and then the judge renders their decision. So that's what happened in this case. If anybody needs that information from the Dalbert hearing, I'm happy to share that transcript as well. Just reach out to me. But if it's not an issue like that, if it's more limiting a scope of testimony, not a full preclusion or exclusion, the judges will often do it just on papers alone. Okay. So look, the key here is that federal court gives you some more tools in your tool chest. And if you plan your motion practice accordingly, summary judgment motions, declaratory judgment motions, motions to exclude or limit expert testimony, it does a couple things. It forces your adversary to deal with it, and you can win. Sometimes it generates enough of an issue that it brings cases to resolution. It's another reporting requirement on the defense side and they have to get paid and they have to work with their experts. I've had many times where motions are pending that then settlement starts to talk. And if you're successful in limiting your adversary's experts, that weakens their position at trial. It's not like state court. There's no surprises anymore. Oh, our expert's going to do well at trial. Well, your expert can't talk about this. You're stuck. So it's really important to do it. You're going to have much more success in your case. You're going to get it resolved faster. So I encourage you to seriously consider motion practice. Don't hide away from it. Roll up your sleeves, get into it, and it's going to make you a much better and more successful practitioner. All right. So this is going to conclude the 3-part series here. I'm so glad you all joined me. We're going to go to the Q&A now. I only see about 13 comments or questions. So either I covered everything so well, which can't be the case. I'm sure I covered a lot of stuff, but come on, put in your questions, put in your comments. I'm happy to get to it. I'm going to go through them all right now. There's no silly questions or comments. And I like the comments more because, as I always say, I certainly don't profess to know everything. I just share my knowledge with you. So when there's other practitioners on these CLEs who can share things in the comments of value, I love that. And I love to continue to learn myself and to share it with others. So let's get to some of the comments and to the questions now. All right. So Dan, how are you doing? He's saying there's a motion to dismiss for lack of jurisdiction. The contract calls for diversity litigation in federal court. Plaintiff chose New York as the venue, the district court with which neither party has any contact, claiming since the contract just says federal court and doesn't say which district, plaintiff can file in any district. Well, that's an interesting point, Dan. You're going to get, so those earlier motions on jurisdiction, those are going to be handled by the district court judge. You may recall I mentioned in the earlier part of the series, we had a jurisdiction issue in front of Judge Kaplan, wonderful, prominent judge in the Southern District, and he brought us in for a conference to talk about it and sort it out before we got underway. So you need subject matter jurisdiction. The court has to have proper jurisdiction over the case and over the parties. And I'm not so sure just because parties draft a contract that says you can file it in any federal court, that's going to give that federal court jurisdiction. I would tend to think it doesn't. I would tend to think there has to be some contacts with the venue. There usually is. So I would check the law for that. I don't think an agreement or a contract can bypass the need to have sufficient contacts for the court to handle it. So I could be wrong, but I would just double check the law on that. And then you're talking about an appeal to the Second Circuit that you defeated. The defendant claims you're not entitled to file a bill of costs because the court decision is silent as to costs. The rule of entitlement to printing costs, it seems to me, doesn't require a court to state entitlement who is right. Again, you're going to have to check the law. Depending on how it goes, the law will control on whether or not you're entitled to a bill of costs. I don't think courts usually, unless it's mentioned in the motion, judge is usually going to be silent on costs one way or another. So I don't think a court being silent as to costs, anything can be read into that. It's going to be controlling by the case law and whether costs are entitled under your jurisdiction and the subject matter of your case. There are some specific cases that costs are always part of it and some that they are not. Matt, how you doing, my friend? He's saying that regarding the assignment of a magistrate, some rules, usually in the Southern District, only permit the magistrate be assigned for all issues, including trial. On the other hand, in the Eastern District, the magistrate is routinely assigned for pretrial and particularly discovery matters, but no matters of substance. So yeah, that's generally how it's going to work. So it's either all or nothing. And again, in smaller jurisdictions like Vermont, they didn't have magistrates, just district court judges. They handle everything. But if you're in the Southern District or Eastern District in downtown and downstate of New York, these dockets are really busy. There's always magistrates, and more likely than not, a magistrate will be designated for discovery. Once that magistrate is designated, then you do have the right, and the magistrate will ask, usually in that initial case management order, whether the parties want to agree to have all issues decided by the magistrate. If they say yes, magistrate does everything, all motions and trial. If they do not agree, the magistrate will still oversee discovery, and then the district court will take the substantive motions and trial. And again, as we spoke of and Matt highlights, magistrates usually allow letter briefs on discovery motions. So much easier in federal court when you have discovery disputes. So Elizabeth makes the point that in New York State, and again, I'm talking federal practice here, but it's good to have the comparison to contrast, that in New York State, I just lost this. Okay. Memorandums of law are generally not included in the record on appeal. So you do that briefinformation or brief affidavit to preserve all arguments. I'm not an appellate expert. So I think to the extent that you want to include that stuff, I would certainly defer to someone who can provide expertise on appellate practice. Okay. Yep. Matt's talking about filing all papers at once. That's called bundling. Bundling, B-U-N-D-L-I-N-G. Some judges have a practice of bundling. I don't like that. I find that to be more work, but I guess some judges and magistrates find that to be easier for them to have everything bundled at once and sit through and read it all. So again, that's why they're the judge. They get to decide what they need, what they want, and how you need to submit it. So follow the rules again. Derek, thank you for pointing out, yes, there is a new amendment, CPLR 2106. You do not need to notarize in state court either anymore. So it looks like we're definitely trending away from the notary requirement, which I find to be really interesting, at least in legal proceedings and motion practice. So, you know, if you're in state court, you don't want to deal with a notary, check out CPLR 2106. All right, I'm being corrected by Tony. The main document when you begin to electronically file your motion is the notice of motion. Thank you for that. I've never gotten bounced on not doing a notice of motion in federal court, but I think the proper practice is, and again, it depends, because if the magistrate is telling you, or the judge, if you're doing a briefing schedule and they're telling you the schedule, when you can file it, then I don't believe a notice of motion is required, because it sets out the fact that you're going to be making a motion and filing with the date. If it's already been predetermined and resolved, then I don't think you need it. But I do agree, Tony. I think the good practice, you should follow what Tony said. Do your notice of motion as the main document, then memo of law and statement of facts, then your affirmation, and go on from there. So thank you, Tony. All right, Don. He's asking about the hyperlinking, if it's verified. Let me explain that. Hyperlinking, you can do this in state court. We do it as well, especially since state court now, so many cases are e-filed. So, you know, when you're doing your preliminary procedural history, summons and complaint was filed on August 1st. Issue was joined by the following and answer on September 1st. Request for judicial intervention on this date, a preliminary conference on that date. And then you're always attaching those as exhibits. An easier streamlined and better practice, you do it in state court and federal court, is you actually just link to the docket number in state court or especially in federal court. So let's say you file the summons and complaint in federal court, and that's docket number 1. And in state court, it's e-filing document 2. Okay. Then what you would do is in your procedural history, plaintiff filed a summons and complaint on such and such date. Then in parentheses, you say C ECF docket number. And what you do is there's a way you can hyperlink that. You pull it up on your computer, you do a copy and paste of the actual link to it when you pull it up in the docket off your browser, and then go in your document, and you could go to insert hyperlink, and it'll actually put a link behind those words and give you a little underline, and then you can click on that. And if the judge or your adversary clicks on it, it's going to bring them to that document. So you don't have to attach it. Now, the reason I said if it's verified and you want to use that in your statement of facts, same way with like a motion for default. So sometimes maybe you've made a motion to dismiss or a default motion. You don't need an affidavit or declaration or affirmation from your client to support those motions if they have verified the complaint and or the answer. A long time ago, we learned that lesson when we moved for a default and we attached the complaint, but it turns out our client hadn't verified it. We used the statute that allowed us to verify it because they were outside of the county of where we were located. The court denied it without prejudice, saying that since it wasn't verified, it's not deemed an actual fact by the party, so we needed to have a verification or an affidavit. So if you're doing it in the statement of facts as a point to showing it as evidence to support your case, you're going to make sure the complaint or document that you're referring to has been verified or sworn to or declaration under the penalty of perjury. Hopefully that all makes sense. But hyperlinking is great. I highly recommend using that. All right. John Gallagher saying statement of material facts is only required for summary judgment motions. I think that's right. I would check the judge's rules on whether or not they want facts in support of other motions as well. Sometimes, like in a motion to preclude an expert, it could be required. And I think we usually do that in our motions to preclude or exclude experts in federal court. Michael, nice to see you. Yep, it's a great way to get rid of experts. Michael's just confirming that, doing the motion practice. And again, there's a lot of experts out there talking a lot of bullshit, and you have to call them out on it. And it's unfortunately in state practice, all you get is a pretrial disclosure. You don't have a deposition. You usually don't even have a report, and you have to kind of do that on the stand. But a lot of these experts are really slick, and they won't give you straight answers. And Irving, sure, you'll see his testimony in my deposition. I mean, he just, when I ask him, can you give me one reference that supports your argument or your opinion that fill in the blank? And he says, yeah, it's the laws of physics. That's how he'll answer it. And, and they just won't give you a straight answer. So it's hard to do that at trial, but in federal court, a federal judge saying their answer that, oh, it's the laws of physics, that's not going to fly. All right. Ashley is asking if I have any pointers on a motion to lift a stay in bankruptcy court. No pointers at all. I'm sorry. I know nothing about bankruptcy court litigation. Sorry, Ashley. All right, Elizabeth, let's see, where are you? Any advice regarding sanction motions for frivolous conduct? So look, in general, state court and federal court, sanctions are not happening unless you can establish a pattern and practice first. You really have to show an extremely willful, intentional disregard for a court order, not just lazy and negligent and all of that. You really have to show some malintent behind it. Any research you do looking as far as sanctions on frivolous conduct, it's going to be really, really hard to establish. But under certain fact patterns, you can. If you've got an adversary who is just demanding deposition after deposition of people totally unrelated, and you trying to preclude it, and the judge, not allowing it, and they're doing it again and again. And, it's generally you're gonna have to establish a pattern. Usually if it's a one-time affair, they're not going to get sanctioned unless you've got real proof. Let's say you get them on the hot mic saying something, so to speak, or an email comes out during discovery where you have, a party or a lawyer, stating something that, let's stick it to them. They won't want to fight this and this will cause them a problem, something like that. Otherwise, don't get too excited. We've seen things that we thought would definitely warrant sanctions, and judges are very, very hesitant to it. I mean, I've asked judges to at least admonish adversaries, and they're shy to do that. I have a pending matter where a judge said you need to disclose your experts all of the required disclosures under the federal rules by May 7th. May 7th came, we didn't get all the disclosures. I reached out to my adversary. I cited the docket text ordering them to give all of the Rule 26A disclosures. They didn't. I said, we want them all today. The judge has ordered it. That was a Thursday. We didn't get a response or an explanation. Friday, no response or explanation. Monday, I send an email to all defense counsel. Where is this disclosure? It was required. I should have it today. If I don't, I'm going to write a letter to the court tomorrow. No courtesy of a response, which, by the way, folks, drives me crazy when lawyers don't respond, especially on pressing issues like this. You need to respond when someone emails you on a pressing issue, even just to say, I'm sorry, I don't have it yet, whatever it is. So anyway, no response. Tuesday comes, I file the letter, and the judge sets a conference for a few days later, because before the deposition. One of the defense lawyers asked for an adjournment, and the magistrate, to his credit, said no. The depositions the following day, we're having this. So we're having this back and forth. And right after I sent the letter to the court, guess what? The disclosure showed up later that day. So we get on, the magistrate said, oh, I see, they filed the letter. They finally gave it to you. So your letter to me worked. And I'm like, yes, Your Honor. I said, but you know what? When the judge, Your Honor, when you issue an order, there's no way I'm not going to comply with that. Your orders need to be taken seriously. And I ask you to admonish defense counsel for not complying with your order, making me write a letter. And I did the whole shebang. And the judge says, well, defense counsel, what do you have to say? It's not an excuse, but an explanation. It was hard getting up with my client. It took a little longer. The judge was like, okay. But moving forward, you should, as Mr. Smiley said, comply with court orders. And I'm like, that's not an admonishment, stick it to them a little bit. So some judges will. On that same situation, another judge may have really, stuck it to them hard. So be careful, folks. Don't be relaxed when it comes to a federal judge's order, or any order for that matter. Judges' orders should be taken seriously. And it upsets me as a practitioner when they're not, whether it's state court or federal court. There's a reason that you get court orders. That's what they're for.
If you're joining us today via podcast, the second attendance verification code is POD 257. Again, that's POD 257.
Okay. All right, Laura is not asking a question, but she's commenting on how timely my comment is on biomedical engineers. I'll now be diving into some research to see about precluding a biomedical engineer is opining on an injury based on impact. Yeah, if they're not a doctor, it's not coming in. And I've used that in state court as an in limine motion to bounce out biomechanical engineers. And then the defense doesn't have much of a defense. If that's what they're relying on. Yeah, you say it's all causally related, then they can't bring in their biomechanical engineer. You've got a treating surgeon who says it is causally related. You win. They lose. Okay. All right. All right, Samantha, for people who do not practice often in federal court, do you have a general recommendation as to what to review or refer to in order to ensure federal court rules that differ from state court are not missed? Yes, Samantha. So I referred to it at the beginning of this presentation. You're going to look at the Federal Rules of Civil Procedure, Rules 7, 56, 12, anything else. It's all searchable too, folks. You can pull it up, download them in a PDF. You could just search motion, the word motion, and they'll all pop up. And look at the local court rules for the district you're in. Then look at your magistrate's individual rules and your district court's individual rules. As long as you've looked at all of those rules, you will be good to go. Don't even worry about state court. Just look at those rules. Okay. Thanks for the nice comment, Gary. Andreas, are there any particular pros or cons, aside from possibly speedier disposition of your case, to consenting to a magistrate? So here's what I see as the pros and cons. The biggest pro is moving your case. You are not going to get a trial date with a federal court judge for a while, primarily because they are going to prioritize the speedy trial requirements of criminal cases. And district court judges have federal criminal cases and they have civil cases. And the cases going to trial, their dockets are usually filled with many more criminal cases than civil. And so they're going to put the criminal trials ahead of yours. And some of them can be really long, especially downstate, the Southern District and the Eastern District. They have huge, gang trials, RICO trials. They have terrorism trials. Some of these trials, I mean, even look at P. Diddy's trial. And that trial is going to be going on for 6 weeks. They have other trials back to back lined up. So you are not going to get a trial date quickly if you are waiting on the district court judge. So that can definitely slow up your case. Magistrates, on the other hand, they don't have trials unless everybody consents. So they're going to be ready to rock and roll. The minute you're done with discovery and your pretrial motions, they're going to give you a trial date. And a magistrate's going to be really into it because they don't get a lot of trials. So they're going to be really diligent, really into it. And I think it can benefit you. On the con side, magistrates don't do a lot of trials. They may not be as good a trial judge. They may be more difficult. They may be more frustrating. So you want to do your homework on who the magistrate is, who the district court is. If you've appeared before that magistrate before and you feel that they gave the appropriate rulings and you're satisfied with how the process went, then, that's what we look at. I would consent again if I had a good experience with the magistrate. If I have a bad experience with a magistrate, I won't consent again. So do a little bit of homework on that. But primarily, unless you see any reason to not like the magistrate, I find it's just much better to proceed. You're going to get your case resolved much faster. So those are the pros and cons about the two. All right, Matthew, who I know knows a lot about federal court practice, is saying New York State requires that all affirmations, including lawyers, must comply with the language in that rule, that CPLR rule. In other words, the old language used for attorney affirmations have been deemed null and void. So check out that CPLR we mentioned earlier, the rule that requires, that allows for attorney affirmations and non-attorney affirmations, and make sure you have the right language. Everybody check the rules. We need to follow rules in the practice of law. All right, Kay is asking, is it common in a med mal or negligence case for the medical insurance company to send letters to the hospital alleging negligence? Have you experienced the insurance company's nurse assigned to the case tell the widow after the death of the plaintiff that the patient had received the worst care in the nurse's career? Kay, that is fascinating. No. If you get a letter from the insurance company alleging negligence, I think that's great. I don't think it's going to win the case for you. I don't think an insurance carrier's letter of negligence is evidence of negligence, but I think it's something worth bringing to the attention of your adversary, and certainly the carrier. If you're the plaintiff, say, look, your own nurse said it was negligent. How are you sitting here telling me otherwise? Let them deal with it. So I think it's helpful. It's not going to I think you can try and get it in as evidence. It's an interesting issue if anyone else wants to comment on it. I'm not sure if an in-house medical insurance nurse's letter is valid evidence to prove liability. That's going to be the issue. It'd be great if it is and you have it. Good luck to you. All right, Don, thank you. Laura's saying is that she believes Rule 202.8G, we're talking state court now, New York State. Statement of material facts as New York State court would no longer be a requirement as of July. Not sure if been discussed or commented on. Again, I'm not knowledgeable on that. Check out your local rules. Check out 202.8 statement of facts. Part of the problem with the practice of law is that not only do we have to follow the rules, but the rules change a lot, right? It's like when you try and hire a company to get your website more action and you pay all this money and they do all this special magic, they say, and then you get no action and they say, oh, well, Google changed their algorithms from when we started and that's why it's not working. Sort of like what we have to deal with as lawyers. The rules change, especially for those long timers who have been doing this practice for decades and we think we know what we're doing. And then all of a sudden we file something like we did 10 years ago because we think we know what we're doing. And then rules have changed. So one of the reasons to go to the academy, a nice plug, Michelle, if you're still there, is we do the CPLR and we do the annual updates every year. So this is when the lawyers who know this subject matter will talk about changes in rules, case decisions that apply to your area of law and cases you're in. So it's really important to go to these annual updates. I do it, my firm, we do it all the time because the goalposts move and you got to know where you're at. Okay. All right, so I think I got through them all. It's 2:22. I guess I covered everything. I'll give a last minute round. If anybody wants to type something in, I'm happy to address it. Otherwise, Michelle, I'll let you hop in. Please reach out to me, listen to the podcast, come to the Academy reception, join the Academy if you're not a member. We want you. We want you in our wheelhouse. We all will help each other make this system better. And when you join the Academy, you can be on committees that have effects on these rules. You can present to the legislature on these rules. We make change. We make the law better for all of us. We do that all the time here at the Academy. So get involved. And thanks for tuning in. I'll see you guys soon.